we need to talk about a major new case that the United States Supreme Court has just agreed to hear. This case could have huge implications for our rights, specifically our right to be free from unlawful searches and seizures, and our protection against the confiscation of firearms from our homes without a warrant. The case is called Case v. Montana, and it builds on an earlier unanimous 9-0 Supreme Court decision that reaffirmed these constitutional protections. That earlier case, Caniglia v. Strom, set a precedent on warrantless searches and seizures inside the home, especially when it comes to firearms. Now Case v. Montana seeks to push that precedent further. At its core, this challenge raises a critical question. Under what circumstances can law enforcement, or even the government, enter your home without a warrant? And once inside, can they seize not only your firearms but other personal belongings as well, all without going through the legal process of obtaining a warrant? For gun owners and for anyone concerned about their Fourth Amendment rights, this case is especially important. If the court rules in Montana's favor, it could potentially allow new legal workarounds for officers to bypass the warrant requirement. If the court rules in case's favor, it could strengthen the protections we already have under the Constitution. Here's how this case began. The lawsuit stems from an incident involving a man named Trevor Case. According to reports, his ex-girlfriend called the police claiming that he had threatened to harm himself and that he might have access to a firearm. The officers who responded to the call already knew Mr. Case. There had been a history of mental health concerns and prior encounters between him and local law enforcement. When 4 officers arrived at his home, they began by looking through the windows into different rooms but saw no sign of him. One officer spotted an empty handgun holster and a notepad inside, which they interpreted as a possible sign that he might be in distress or preparing to harm himself. The officers knocked on the door repeatedly. They also shined flashlights into the windows, but there was no response. They waited outside the home for approximately 40 minutes. During this time, they discussed the situation among themselves. Several of them expressed concerns about entering the home, especially given their past interactions with Mr. Case and the warning from his ex-girlfriend. Some feared that forcing entry could result in a violent confrontation. There was even talk about alternative approaches. They considered contacting Mr. Case's father, who might have been able to safely enter the home and speak with him. They also discussed trying to call Mr. Case directly on his cell phone to see if he would answer. However, in the end, none of those options were pursued. Instead, the officers decided to act. They noted that the front door was unlocked. Before going in, they retrieved rifles and ballistic shields, preparing for the possibility of a dangerous encounter. Then they made the decision to enter the home without a warrant. When the 4 police officers entered the home, 2 of them went downstairs while the other 2 headed upstairs. One of the officers who went upstairs entered a bedroom and noticed that a curtain suddenly moved. As it shifted, he caught sight of Mr. Case's face, and also noticed what he described as a black object in his hand. Reacting instantly, the officer fired, striking Mr. Case in the arm and then in the stomach. Medical assistance was given on the spot, and once Mr. Case was stabilized, the officers searched the house. During that search, they found a handgun in a laundry basket, located near where Mr. Case had been. These events led to criminal charges against Mr. Case. He responded by arguing that the officers had violated his Fourth Amendment rights by entering his home without a warrant. He also claimed that the handgun and other evidence found inside should be thrown out. The lower court rejected those arguments, and the case eventually reached the Montana Supreme Court. In a narrow 4-3 decision, the Montana court ruled against Mr. Case. Now the matter has made its way to the United States Supreme Court, which has agreed to hear the challenge. The central question before the Supreme Court is this: can law enforcement enter a home without a warrant based on less than probable cause if they believe an emergency is taking place? Or does the so-called emergency aid exception require full probable cause before officers can make a warrantless entry? In his petition, Mr. Case argued that while the Supreme Court has recognized certain exceptions for urgent situations, it has always been cautious and precise in defining those exceptions. He urged the court to take the same careful approach here, and to make it clear that officers must have probable cause, not just a hunch, before entering a home without a warrant in the name of emergency aid. He also pointed out that in Caniglia v. Strom, the Supreme Court rejected the idea of a broad, standalone community caretaking exception to the Fourth Amendment's warrant requirement. But the Montana Supreme Court upheld the officer's entry into his home based on exactly that type of reasoning, using a community caretaking test that required only reasonable suspicion of an emergency. Mr. Case argues that this standard is far too lenient, directly conflicts with the Supreme Court's ruling in Coniglia, and ultimately weakens constitutional protections. The dissenting justices in the Montana decision agreed with Mr. Case's interpretation, emphasizing that Coniglia tied the concept of community caretaking directly to existing exceptions like exigent circumstances, and that these exceptions still require probable cause. In their view, Montana's ruling ignored this and applied its own, less stringent standard. For context, here's what happened in the Coniglia case, which plays a key role in this debate. A husband and wife had an argument during which the husband placed a handgun on the table and told his wife to take it and put him out of his misery. Alarmed, the wife left the house and stayed at a hotel for the night. The next morning, unable to reach her husband, she called police. Officers arrived and found him sitting calmly on the porch. They decided to have him taken to the hospital for a psychological evaluation. Before leaving, Mr. Coniglia told officers he did not want them to take his guns, and they agreed. But after the ambulance left, officers went to the wife and falsely told her that her husband had consented to them removing the firearms. Believing this, she allowed them into the home, and they took the guns. That case reached the Supreme Court in 2021, and in a rare, unanimous 9-0 decision, the court sided with Mr. Coniglia, striking down the use of the community caretaking rationale for entering a home and seizing property without a warrant. Since that 2021 ruling, the Supreme Court has not reviewed another case involving the limits of warrantless home entry, until now. The case challenge could not only reaffirm the principles set in Coniglia, but potentially expand or clarify them, shaping the future of Fourth Amendment protections. Recently, amicus briefs have been submitted in support of Mr. Case to the United States Supreme Court. One of these briefs came from the Long Institute, an organization that advocates for the principles of natural law and the laws of nature and nature's God, as recognized in the Declaration of Independence. In their filing, the Long Institute argues that the framers of the U.S. Constitution understood a hard truth. The government is neither compassionate nor a caretaker. They recognized that civil government ultimately operates through force and coercion. They point to the Bible's account in 1 Samuel 8, where God himself warns that earthly rulers will take the people's land, harvests, and property, conscript their sons and daughters, and wage wars. With this understanding of the state's potential for abuse, the framers sought to safeguard the family, its rights, and its property from the reach of government and its agents. They deliberately enshrined certain protections in the Bill of Rights, including the Second Amendment, to ensure citizens could resist and push back against such infringements. According to the Long Institute, the Second Amendment's clear prohibition against infringing on the right to keep and bear arms is a vital safeguard for both personal freedom and the sanctity of the home. Based on these principles, the Long Institute contends that the Montana Supreme Court's ruling directly undermines the framers' intentions and should be overturned by the U.S. Supreme Court. What makes this moment especially significant is that multiple organizations are now rallying behind Mr. Case, filing their own briefs in support. This case has the potential to shape how far police and government agents can go under so-called warrant exceptions, and whether those exceptions can be used to justify entering someone's home without proper judicial approval. The Supreme Court now has an opportunity to address and clarify these issues, potentially building upon its unanimous 9-0 decision in the Coniglia case. That ruling reinforced the Fourth Amendment's protections against unreasonable searches and seizures, and a favorable decision here could further strengthen those protections for all Americans. This is not just a legal battle. It's a critical question about the limits of government power and the rights of every citizen to be secure in their home. The outcome could have far-reaching consequences for how the Constitution is interpreted in matters of privacy, property, and personal liberty. We'll be following this case closely as it moves through the Supreme Court. Once arguments are heard and a decision is reached, we'll update you on what it means for your rights. If you found this update helpful and want to stay informed, consider subscribing to the channel so you won't miss future coverage. As always, thank you for your continued support.